All right, ladies and gentlemen, it's about 9 o'clock. I'm going to call the dockets, ask for announcements from attorneys. Anyone who's present who doesn't have an attorney or your attorney's not here, please make sure I know you're here. And apart from that, please make sure your device is muted. Start with the Atascosa. Give me a moment. Give me just a moment. Okay, start with the LaSalle County case 138206 in the interest of RN, a child.
Your Honor, we got a call this morning that the setting is dropped from Attorney Donato Ramos, that the defendant is deceased.
Okay. Luis Ayala Jr. and Alderman Place 4 versus the City of Cotulla.
Your Honor, defendants are here present and ready. We're the movements on the motion for judgment non-proton. We think it would probably take about 20-25 minutes.
This is Charles Sierra for the plaintiffs. That's fine, 20 minutes.
Okay, I'll mark you 20 minutes.
Your Honor, Art Martinez Devar, I'm co-counsel with Mr. Sierra. I agree with this 20 minutes.
Okay. All right, give me just a minute. I just purchased a monitor stand so I can have my second monitor vertical so I can see the entire page at once on the dockets. And that's great, but whenever it did that, because it's narrower, it has hidden all the icons I need to use, and I have to go and fish around for them and click buttons to get to them. So I don't think this is gonna continue. Cnty Petroleum, or Centris Corporation number 2 versus Gallup Petroleum.
Morning, Your Honor. Alan Russell here on behalf of the plaintiff, the movement, Cnty Corporation. It's a default. It's liquidated. I think less than 5 minutes.
Right, number 1. Okay. Let's go to docket in the interest of Joseph and Anthony Vasquez, children.
Yes, Your Honor, I'm present on that. I don't see my client on. I'll have to check with him. Judge, the respondent is currently in federal custody. She told my client yesterday she was hoping to be able to get on. We sent them the Zoom link, so we may need some time to see if she actually is going to get on. Otherwise, we'll be asking for a default.
Okay. Mark, you conferring. In the interest of Willow Grace Marler, a child.
I'm present on that, Your Honor. I don't know if Mr. Gears joined yet. He had an AG setting at 8:30, but we need about 30 minutes on a motion for enforcement for possession. And I think he stipulated to the exhibits, there's 3 sets of them, so it shouldn't take but about 30 to 45 minutes at the most.
Okay, I'll mark you 30 minutes and we'll wait for Mr. Gear. In the interest of Bentley and Whitaker and Gannon and Shaka, children?
Yes, Your Honor, that's actually a divorce proceeding. And I believe the person named Brooke with the E on it is my client, Brooke Menchaca. And it's a prove up of a divorce. Mr. Menchaca is in the Atascosa County Jail. I don't know if he's asked to join or not. We served him with notice. He was reset from, I think it was last week when Judge Ellison didn't get to this case or the Marler case. And we sent him certified mail notice at the jail, Atascosa County Jail.
Okay. I'm going to ask.
I mean, I can contact the jail if you'd like and
I'm gonna
see if
ask
he's
you to-
planning on.
To call booking and just see if he's requested, not that they need to suggest it to him, but that see if he's requested to be able to join this.
All right, Your Honor. The only other thing is at 10 o'clock, I have a brief hearing in front of Judge Brendel. So I'll go on a different device. I'll stay in this meeting, but at 10 o'clock, I'll be gone for about 15 minutes. But let me call the jail.
Okay, there's no problem.
Judge, with just hearing Lucinda say that, I also have something with Judge Brendel at 9:30, should take 10 minutes. Just
Okay.
letting you know.
Thank you. On the add-ons for Atascosa County, 1811-410. Oh, no, I'm sorry. 1811-410 Frio, in the interest of YHR a child.
I'm here on that, Judge. It's a motion to enter from a hearing yesterday. Opposing counsel approved the order. I just need to submit it to the court.
All right, can you submit that to me in chat?
Yes, Judge.
If you'll do that, I will sign it, and I'm not sure if Frio County is on, Dahlia is there. Okay, so I'll sign that.
Thank you. I did see it in the e-file, but I wanted to make sure that you probably wanted it through chat.
Okay, yes, I'm gonna go back and start working on e-file. I was here till almost 6 last night, and I didn't get anything done on e-file because we kept going.
Well, I haven't forwarded since I thought that maybe you would want it through chat this morning.
Yes, I appreciate that, but
Okay.
I looked at e-file this morning, and there's 2 pages of things that have appeared since.
Correct.
Okay, Karnes County, in the interest of Ryan, Noel, Brian.
Your Honor, I'm present for that. Grace is answering another docket right now, and then she said she would pop back on, but that's her motion to revoke.
Okay, how long to hear?
Probably not more than 30, 45 minutes.
Okay. All right, I'll mark you 45 minutes in concurring.
Thank you, Your
Anyone
Honor.
else told to be here today? Your case was not called? No? Okay.
Your Honor,
Yes.
I did have a criminal case on Wilson County that was for amended bond conditions. I don't know why it's not on the docket, but those are agreed. And I will just submit it in chat for your signature. The DA's office has agreed to amend the conditions.
Okay.
The Wilson County dockets with Judge Ellison.
Oops. Okay. Well, that would be wise, but it's still not on there. I'll jump over there in a bit.
Okay. All right. Anything else?
Your Honor, we did have an addition to the Atascosa docket,
Okay.
1906-0534.
Hold on just a second. Again, I don't think I'm going to keep this vertical monitor. We'll see. 060354?
0534, yes, sir.
53.
Martinez versus Blaylock Trucking.
Okay. Is anybody here on that case?
Yes, Your Honor. Movement is here on behalf of Blaylock Trucking and Mario Herrera. And I think I have reached an agreement with opposing counsel, and we can reduce it to writing.
Okay.
Well, we do need to loop John Shaw in though.
Yeah, John Shaw here for the plaintiff, estate of Michael Martinez.
Okay, so can I put you in a breakout room?
Yes.
Sounds good.
Okay, any other announcements?
That's it, Your Honor.
Okay, so breakout room number 1, we need Thornton Summers, John Shaw, and who else?
Larry Wasmiller.
Larry Wasmiller. Okay.
Thank you, Judge.
All right, I just opened that breakout room. Anyone else need a breakout room? All right, Mr. Russell.
Yes, Your Honor. I'm ready.
All right. Give me just a second. Okay. do you have a copy of your return of service? Because I do not have access to the district clerk records in LaSalle County.
I do have it right here in front of me. Looks like it was e-filed on October the 26th at 2:25 PM.
Okay. I'm not doubting that. If you could post a copy of that to me in chat, I'd appreciate it. And any other documents, judgments, or exhibits, anything else you want me to look at?
Okay, yeah, give me a second.
And on the City of Cotulla case, if there are any documents I need to look at, if you would post those to me in chat, I would appreciate it.
Yes, Your Honor. I'll post the motion.
He's gonna need the order too.
I can do that.
All right.
Your Honor, I'm going to have to scan the citation return. Apparently, I don't have an electronic copy, but I will do that right now.
All right, thank you. And just to make things more fun, I installed an update on Zoom yesterday, and some of the commands have changed. Not a whole lot, but just enough to slow me down a bit. So. All right, Dolly, I just sent you the temporary orders with my signature.
Okay, I got it, sir. Thank you.
All right, you're excused. Have a good day.
Thank you, Judge.
Thank you.
I see a Joseph's iPhone. Is that Joseph Vasquez?
Yes,
It
sir.
is, Your Honor, yes.
I'm going to change the name. Okay, go ahead, Mr. Russell. I've reviewed the return service. Okay, go ahead, Mr. Allen. Are you ready?
Yes, Your Honor, I have attached the PDF of the service return, and I'm having my secretary do a PDF of the entire motion with all the attachments and exhibits. I don't know if you have that in front of you, but in case you wanted to talk about the affidavit and the contract and the various invoices and all the other items that I've attached, that's a work in progress. So we can start now without that, or if you have that, I can work from what I've got, or if you'd like, I'll have it all scanned in to show you that in a moment.
I'd like to look at it. I don't have it yet.
Well, hold for just a moment. I apologize. I didn't anticipate that, and I thought I had a scanned copy, but I don't. So we're doing that right now.
And like I said, with the other 4 counties, I have electronic access to the district clerk's records, and assuming it's working, which is more often than not, but not all the time, it wouldn't matter.
Not a problem. Just give me a couple of minutes and I'll have it all before you.
Sorry.
Okay, and I've looked at the motion for judgment nunc pro tunc, and I don't know if the attorneys want to chat in a breakout room. My intention was to enter an interlocutory order.
Right, that's what I believed. And I don't understand why they're doing a judgment non-protunct. It's not a final order. You've got denied in several places and granted in
Yes.
part in several places. So it's not a final order to even be talking about.
That's correct. That was an interlocutory order.
On your order,
Well, I'll talk to Mr. Pena about it then, and we can, see what else we need to do on the case, but that's not a final order that needs to be touched right now.
All right, let me put you all into a breakout room if I can. Breakout room 4. Yes. Alan and Steve Pena. Okay, you should have all received an invitation to breakout room 4.
Your Honor, I don't see an invitation.
Oh, I'm sorry, Mr. Martinez.
No problem.
There you go. Thank you.
Thank you.
Okay, Mr. Russell, I have your exhibit or whatever it is you sent of 22 pages. I'm looking at it. Go ahead.
Okay, sorry about that. It's not organized. I mean, these are the exhibits A through E. The first page being the first exhibit being the contract, which is a 3-page document. That's what this case essentially is about. My client, Cnty Corporation, had a contract signed to provide various products to Gallup Petroleum. You'll see on the exhibit, the first page, the exhibit, it's a 60-month agreement, 5-year commitment. On the second page, it's signed by the owner, Salim Gorer, I guess is how you pronounce his name. Paragraph 11, which is on the third page, actually has the liquidated damages clause in it, which comes into play when they don't fulfill the full term. That's Exhibit A. Exhibit B is an affidavit from Chris Vanderplatz, who's the general manager of my client. It breaks down, identifies the contract, breaks down the breach and the damages, the liquidated sum, which consists of 2 things. In paragraph 4 of his affidavit, he breaks down unpaid rental charges. They charge rent every week for the products that are provided. And the Gallup Petroleum got way behind on paying their rental payments. So paragraph 4 of his affidavit specifies that amount, $5,192.78 in unpaid rental charges. That also is detailed in Exhibit C, which is an account, basically a ledger statement for the account, shows the individual invoices, dates, and amounts that comprise that total charge. And as I mentioned before, paragraph 11 has a liquidated damages clause for early termination since they had contracted for a full 5 years. Obviously failed to pay. The dates of the termination and the number of weeks remaining are all calculated in exhibit number 5 based on the average weekly sum that is all calculated in the exhibits that are exhibit number D. The invoices, I'm sorry, that are exhibit number D. That amount adds up to this $14,771.12, all of which is broken down again in exhibit B, the affidavit, paragraph number 5. I've also attached an affidavit in support of an attorney's fees claim for $2,500, along with our proposed judgment. The other item, I guess, that was scanned in that you should have is the service return showing that the process server actually served them at the business location on, looks like August the 13th. So that would put their answer was due on September 7 of 2020, and we have received no answer at this point. For all those reasons, I guess default is appropriate, and that's what we're seeking here today.
All right. Whenever your proposed judgment was run through the scanner, it got mangled. The second page is crumpled.
Oh,
folded, spindled, and mutilated. If you could rescan that. And Mr. Carvajal?
Yes, sir.
I just want to check and make sure, has there been a pro se answer filed?
Let me check right quick.
About 10% of the time, Mr. Russell, when people try and do these, there's a pro se answer that the attorney wasn't given notice of.
I understand, and we try to check that, but I appreciate that, absolutely.
No, Judge, there's been no answer.
Okay, then I will send the judgment whenever it comes back to me.
I will resubmit it. I'll stay on the line while I do that and make sure you get it.
Okay, all right, thank you.
Thank you.
Okay. All right, Ms. Vickers, are you ready to proceed on any of your cases or?
Yes, Your Honor, on Whitaker and Menchaca, in the matter of the marriage of Menchaca, I have contacted the Atascosa County Jail, and I have certified mail notice signed for by the jail on November 15th, and they confirmed they delivered it to him, telling him about today's setting with the Zoom information attached. I don't know if you want me to submit that. I can. It's not.
No, that's just go ahead and file it if you're going to file your return. But no, just go ahead.
All right. Well, he has not filled out a request form to participate in today's hearing.
Okay, that's fine. All right, Ms. Menchaca, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Go ahead.
All right, Ms. Menchaca, would you state your full name, please?
Brooke Taylor Menchaca.
All right, and are you currently married to Emery J. Menchaca Jr.?
Yes.
And were you married to him on or about March 20th of 2019?
Yes.
And did you separate from him on or about January 15th of 2020?
Yes.
Has the marriage become insupportable because of conflict of personalities between you and Mr. Menchaca that destroys the legitimate ends of the marriage?
Yes.
And you've been a resident of the state of Texas and Atascosa County for the last 6 months, is that right?
Yes.
Okay. And you are currently not in a bankruptcy, and as far as you know, Mr. Menchaca is not in a bankruptcy, is that right?
That's correct.
Okay. You and Mr. Menchaca are the parents of two boys, Bentley Gage Whitaker and Gannon Wayne Menchaca, is that right?
Yes.
All right. And briefly, we're not going to get into a lot of detail here, but briefly, Mr. Menchaca is currently on a no bond for violating his bond from his arrest for physically attacking you, and he's currently under indictment for aggravated assault with a deadly weapon. Is that correct?
Yes.
All right. Now, you suffered obviously some real serious injuries because of his attack. Is that right?
Yes.
And you are asking the court to appoint you as the sole managing conservator of these children and to make Emery the possessory conservator of the children. Is that right?
Yes.
You want him to have visitation as directed under the advice of a therapist. Is that correct?
Yes.
Mr. Menchaca has engaged in family violence for several years against you, and the children have been witnesses to this. Is that right?
Yes.
All right. Are the children currently in the care of a psychiatrist and a therapist?
Yes.
And are they receiving any medication as part of their therapy?
Yes, they are.
And are you currently under the care of a psychiatrist and a therapist?
Yes.
Are you currently receiving medication as part of that care?
Yes.
And you think it's in the children's best interest to have visitation in a supervised, limited setting at the direction and under the instruction of a therapist, and that's what you're asking the court to order. Is that right?
Yes, ma'am.
All right. Now, you and Mr. Menchaca, there's not a lot of property to be divided up in this marriage.
No.
All right. So you want to keep whatever you have, and he can keep whatever he has as part of the divorce, correct?
Correct.
Do you still have the 2018 Chevrolet Tahoe?
No, I do not.
Okay. Do you have any cars in your name?
I have a 2017 Nissan Maxima.
And you're asking the court to award that to you?
Yes.
All right. Is there any other property of any value that you would like to have in this divorce?
No.
All right. Now you are asking that your name be changed, and you want it to be changed.
Hey,
What?
I was thinking a couple of things.
Mr. Pena? Mr. Pena? Okay, all of y'all are back, it looks like, from
Yeah,
the.
I'm muted.
Okay, you weren't there for a second.
Okay, hold on. Okay, did y'all return back to the breakout? Okay, I muted.
There he goes. He's muted.
Okay, all right.
All right, Brooke, what did
Go
you
ahead,
want to
Mr.
change your name to?
Or
did you want to?
I didn't think so, like right at this moment with all of this Corona thing. I don't know how that all works with going to the Social Security, and I don't know what's happening.
So right now you're going to leave your name the same.
Yes.
All right. So you're asking the court then to approve what you've requested and grant the divorce. Is that right?
Yes, ma'am.
All right. I have nothing further, Your Honor.
Okay, I'll find I have jurisdiction. Actually, Mr. Russell, I posted that back to you, Mr. Carbajal. I would appreciate it if you could file the order with the e-file. And
Okay, sir.
all right, thank you. All right, I'll find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. The return of service has been on file. Required period of time. There's no, the respondent was given notice via Rule 21A of this hearing and has not appeared. And he has had the opportunity to request to be able to appear via Zoom and has not done so with the Atascosa County Jail. Petitioner had been a resident of Atascosa County for 90 days and Texas for 6 months before the lawsuit was filed. And I believe the children were actually born prior to the marriage. Is that correct?
That's correct, Your Honor. Mr. Menchaca is listed as the father.
Right.
And then there was a marriage after their birth.
There are children of the relationship. And are you expecting a child right now, ma'am?
No, I am not.
But there are no more children expected, and I find that the orders concerning the children are in their best interest, and I approve them. And I will specifically find that the presumption that Mr. Menchaca should have significant unfettered access to the children has been overcome by clear and convincing evidence. And I will also take judicial notice without objection of the testimony offered in the bond and writ of habeas corpus hearings on Mr. Menchaca arising out of the criminal charges he's incarcerated for or jailed for. I'll find
Your
the
Honor, I'm sorry. The only thing I didn't mention was child support. We have a temporary order in this case. That's the last information we have as to Mr. Menchaca's earnings. At this point, I don't know what his earnings are. We would request that the child support stay the same as in temporary orders, because that's the last income information. Obviously, he's not working. I mean, at this point.
Yes, I'll leave child support the same and I'll suspend that while he's in jail. And I'll find the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. Do you have your proposed divorce decree, Ms. Vickers?
Your Honor, I need to fine tune it a little bit. Hopefully we'll have it later today that I can then submit. Do you want me to submit it through the e-file system?
E-file is great.
Okay, thank you. And Your Honor, may Ms. Menchaca be excused?
Yes, she's excused.
Okay.
Thank you.
All right, and do we have an announcement in the City of Cotulla case?
Yes, Your Honor. I'm waiting for the other side. They were going to drop their motion.
Yes, Your Honor, we're going to pass the motion for now. We'll see how the case proceeds and address any issues at a later date.
All right. I hope you have a good holiday.
Thank you.
All right, thank you, Judge.
Happy Thanksgiving.
Okay, Mr. Carvajal, I think that's everything. You're excused if there's nothing. Thank you for being here. Have a good Thanksgiving.
Thank you, Judge.
Okay. I just found out that if you remove somebody from Zoom, which I do once in a while, there's a new option that it reports them to Zoom, but I managed to cut that off before I reported that attorney. Okay, Whitaker, where do we stand?
Are you talking about my case we just finished, Your Honor? The other one I'm waiting on is Robert Gear. It's Marler, in the interest of
Oh,
Marler.
Marler, yes, yes. Okay, I'm sorry.
Let me text Robert. I don't see him. Like I said, he had an 8:30 AG hearing he thought would take 20 minutes, but let me see if I can locate him, all right?
Yes, go ahead. I'm sorry.
All right, that's okay. And then at 10
I read
o'clock,
the-
I'll go to Judge Brendel.
That's
Let me
fine.
text him.
I think Ms. Harkins is in county court at law. Okay, and on Martinez versus Blaylock Trucking, is everyone left? Apparently. Norma, did they?
I think they all
contact you?
left. No, sir, they didn't.
All right, I guess they worked out their continuance, okay? We'll start working on the judges' queue. All right, let me know when we're ready to move on something.
I'm going to take a quick potty break, Judge. I'll be back.
All right, do we have anything that's getting ready to proceed? The attorneys need to confer. I saw Mr. Gear appear for a moment, then he went back away.
Judge, I'm ready to proceed when the court's ready. It should take about 15 minutes max, I think.
All right, and let me get an announcement. Mr. Gear just popped back in. And Ms. Barrera, on your case, let's see, Ms. Tapia is gone.
She was announcing with Judge Ellison also. I'm not sure
Okay,
if she was
okay.
done.
Okay, if you would send me a copy of whatever I need to look at, just post that in chat. I'd appreciate it.
Okay.
All right, Mr. Gear.
Morning, Judge.
Morning, sir. What is your announcement?
I have I guess, an enforcement with Lucinda, with Miss Vickers.
She thought about 30 minutes.
Yeah, if that. Basically, we've kind of smoothed out the issues. I think the only thing really is attorney's fees.
Okay. All right. I'm conferring, and she had to go and make an appearance in either AG court or county court at law. I'm not sure.
Okay, yeah, she did say she had to prove up with Judge Brendel.
Okay. All right. And Ms. Harkins, how long to hear your matter?
Judge, I think about 15 minutes.
All right. And who is on the other side?
Judge, her name is Deborah Goldman. She's the person in federal custody. We sent them the Zoom, but they said they didn't know if she could get on.
Okay. And is Edward Balderas still involved in this case?
Judge, the AG's office had been involved in some of the earlier filings. We sent them notice. I don't see anyone here. Do you want me to give them a courtesy call?
Are you trying to change anything that will affect them?
Judge, we were just going to ask that Ms. Goldman be ordered to pay minimum wage child support. So, and we would just send them an order, but that's all.
Okay, and typically they will not try to enforce that absent extraordinary circumstances, I believe, for a time when the obligor is incarcerated.
I understand, Judge. I let my client know that, and he wanted us to ask for that.
Okay, all right. So do you need to swear someone in?
Judge, just my client, Joseph Vasquez. Joseph, you can unmute.
If you'd raise your right hand. Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, go ahead. And let me just ask, there's an eye chopper XS. Who is that? I'm asking the eye chopper XS.
That might be my client, Judge.
I'm sorry, can you hear me?
Yes.
Yes, that's me, Chad Marler, sir.
Chad who?
Marler, M-A-R-L-E-R.
Thank you.
That's my client.
All right. Okay, I just wanted to make sure we didn't have somebody else involved in this. All right, go ahead, Ms. Harkins.
Thank you, Your Honor. And at this time, I'll ask that you take judicial notice of the contents of the file, including the officer's return on the citation, as well as the officer's return on the precept for today's hearing.
All right, I'll take judicial notice of the entire contents of the file.
Thank you. Are you Joseph Vasquez?
Yes.
And are you the father of Anthony Ray Vasquez and Joseph Wayne Vasquez Jr.?
Yes.
And is their mother Deborah Sue Goldman?
Yes.
And are you here today asking the judge to modify the current orders?
Yes.
And how old are your kids?
9 and 8.
And under the previous order, who was named as the primary conservator of the kids?
She was Deborah Goldman.
And in the last, for 2020, have the kids been with you sometimes and been with her sometimes?
Yes.
And explain to the judge kind of how that's gone as far as you having the kids some of the time.
Back in March, I had the kids for March and April. CPS was called on Deborah. Some domestic violence is going on in the house, so they placed the kids with me under a child's, I guess it's a safety protection. I'm not sure exactly what it's called. They
Was
were
it a
with me
safety
for,
plan?
yeah, safety plan. And they were placed with me for a couple months. She was doing counseling and doing what she needed to do. So they were placed back with her. And when they were getting ready to close the order, she was arrested at the, I'm not sure exactly where she was arrested, but she was arrested for smuggling illegal aliens. And I had to pick up my son from school. She didn't drop him off that day. The neighbors dropped him off for school, so I had to pick him up early. And then I've had him ever since.
Okay, now your oldest son, Joey, had he been staying with you at the
Yes.
time that Ms. Goldman was arrested?
Yes, he was with me for about 2 or 3 weeks before that. He noticed that she started bringing around another gentleman while her husband was in jail, so he didn't want to be there. He asked me if he could come stay with me, and I said yes.
And did Ms. Goldman agree to that?
Yes.
And so at the time that Ms. Goldman got arrested, do you remember the date of the arrest?
I can check. I know it was mid-October. I'm not exactly sure what day it was. I received a message from her brother stating that she was arrested.
Okay, does October 23rd sound right?
I think it was I think it was before that.
Okay, so at that time that she got arrested, where was your son Joey enrolled in school?
Sinclair Elementary in San Antonio.
Where you live?
Yes.
And where was Miss Goldman living at that time?
In Jordanton, Texas.
And is that where your youngest Tony was enrolled?
Yes.
And when you found out that Miss Goldman had been arrested, what did you do?
I picked up both of my sons from school. I picked up Joey first, and then I went straight down and I called CPS to let them know. I called you, and then I called the Jordanton school and told them I'd be withdrawing Tony. And so I picked him up.
And have you had a chance to talk to Miss Goldman since she's been in federal custody?
Yes.
Did she call you?
Yes.
And was she able to tell you anything about the process of her case and where it stands now?
She was supposed to have a court date at the beginning of November. It got postponed. The last I heard was a few days ago. She said she wouldn't have a court date till the new year.
And where is she in custody?
I think it's the ICE Correctional Facility in Valverde County.
Okay. Now, you're here asking for the judge to make a modification for purposes of temporary orders. Is that correct?
Yes.
And are you asking that you be named the primary joint managing conservator
Yes.
with Ms. Goldman named as the possessory joint managing conservator?
Yes.
And are you asking that in the event that Ms. Goldman can have any visitation, that it be on the 1st, 3rd, and 5th Saturday of the month from 3 to 6 p.m.?
Yes.
And are you asking that, yes, are you asking that that visitation be supervised by you?
Yes.
And the judge already mentioned on the record about the child support. Are you asking that she be ordered to pay any child support?
Yes.
And I mean, do you understand that she's incarcerated at the moment and obviously isn't making any money? Is that right?
Yes.
Okay. And are the kids currently insured?
At the current time, no. I'm still in my 90 days at my job, so I have to fill out the. I was waiting for Medicaid to come back to see if I would be able to get Medicaid, and they denied me, so I have to go through my job.
So do you plan to get private insurance coverage soon? Okay.
Next week.
Okay. And okay. And do you have anything else that you're asking the judge to modify at this time?
No.
Judge, that's all I have.
Okay, I'll find I have jurisdiction to hear this matter, and I will grant the relief prayed for. Do you have a proposed order?
I don't, Judge. I thought she would appear, and I wasn't sure what the court would order, so but I can get that to you today.
Okay, and this is on temporary orders?
It is, yes, Your Honor.
Okay, because we don't have a military service affidavit, but I think if she's in federal prison, she's not in custody, she's not in federal service. Okay, thank you. I will put reset on request, and you can, if you want to just e-file that, I will sign it whenever I get it.
Yes, Judge, we will do that. Thank you very much.
All right, have a good day.
Thank you. Joseph, you can leave the meeting.
Okay, thank you.
All right, Your Honor, I'm sorry. I'm back from Judge Brendel's court. So I see Mr. Gear has joined us, so I guess we're ready whenever you are.
Okay. Mr. Gear.
We're ready, Judge.
Okay, do we need to swear anyone in?
Yes, Your Honor. My client is Megan Monk, and she appears on the screen as Megan Monk. And Mr. Gear's client, I believe, is Chad Marler, who appears as Chad Marler on the screen also.
All right, Ms. Monk, would you unmute your electronic device? Will each of you raise your right hands? And Mr. Marler, are you driving?
I'm sitting in a vehicle, Your Honor.
Okay, all right. Just make sure you weren't on the way. All right, each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I do.
All right. And your name, ma'am?
Megan Monk.
Your name, sir?
Chad Marler.
All right. And whose motion is this, and what motion is it?
Your Honor, it's my motion for enforcement of visitation. And we've had some makeup visitation, but we have been unable to agree as to whether or not Mr. Marler is in contempt. And if so, how much attorney's fees he's going to be required to pay if you find him in contempt. So that's where we are. We need to show that he's in contempt, and then I'm going to prove up attorney's fees, and Mr. Gear can present whatever defenses he's going to present.
Okay. And Mr. Gear, do you have any opening statement?
Yes, Judge. May it please the court. Judge, Ms. Vickers, on behalf of her client, filed a motion for enforcement in this matter. We conferred and entered agreed temporary orders in this matter on July 10th, 2020, which basically resolved all the issues of contempt. It did allow for makeup days for visitations missed, and we provided all the information that Ms. Monk was requesting in regards to the children. I do know that this is a formality and what have you. I do understand the argument as to attorney's fees. It is our argument that the court consider any, well, we'll close with that, but consider any evidence of attorney's fees as per the reasonableness of the matter. There were 3 violations alleged of 1-hour visitations. So we'd like the court to keep that in mind as the evidence is presented. Thank you.
Okay. Your first witness?
Your Honor, before we begin, Mr. Gear, I believe, was willing to stipulate to, I have 3 with the motion and 1 extra one. They are exhibits that I can email to you, and I believe he's willing to stipulate that these are indeed the things that they purport to be. But I haven't emailed them to you. I'm not sure how you want to receive these.
I would prefer if you can just send them via chat. Just
Okay.
Go to chat, click next to my name, and most of the time, a little box will appear to the right that will allow you to send files either directly to me or to everyone.
Okay, and since I've never done this before, I guess I'm going to have to scan. Okay, I don't know how to do this.
All right, if you'll go to chat and then.
Okay, I see. I don't have it on this. This computer's not hooked up to. Oh, I'm going to do that.
Okay, you can email them if.
Yeah, I'm sorry, Your Honor. This computer, it's my laptop. It's not hooked up to any of the devices that would allow me to scan and attach. Okay. So I'd have to spend time. I see how you do that, but I'd have to spend time doing that. Okay, I apologize.
E-filed?
I believe, let me look. They may be attached. 3 of them may be attached to my original motion for enforcement. I can't remember.
I was just thinking you probably already have a PDF copy somewhere, it sounds like, if you e-file them.
I may have it. Robert, do you remember if I attached them to my motion?
I don't think you did, but I'm looking to see if I received them from you. I know I did.
Yes, you did. I'm just trying to get them to the court. I may not have attached them, Your Honor. I'm sorry. I thought I might have, but it's been so long that I don't. It doesn't look like I attached them. Let me see. I apparently did not attach them, Your Honor. Would you be willing to allow me to email them to you for this purposes of this hearing?
Yes.
All right, let me get that started. Hang on just a second.
Okay, Ms. Tapia, I saw that you had appeared. Would it do any good for you and Ms. Barrera to confer in a breakout room? Or?
I'm willing to confer, Your Honor. You're
Barrera,
muted, Grace.
We can confer, Your Honor.
Okay, let me. Okay, you should have each received an invitation to breakout room 8.
Thank you, Your Honor.
Your Honor, my secretary is emailing them to you right now. If you want to, we can start with the testimony, and then when you receive them, you can let me know.
All right, go ahead.
All right. You've sworn in my client, Your Honor, so let me start. Ms. Monk, would you state your full name, please?
Megan Diane Monk.
And Ms. Monk, you are the person who filed this enforcement to enforce your possession and access to Willow Grace Marlar, is that right?
Yes, ma'am.
Under the order from July 17th of 2019, what is your visitation?
I get 1 hour on the first, third, and fifth Sunday of the month.
Okay, does that begin at noon and end at 1 and is to occur at Sonic in Pleasanton?
Yes, ma'am.
All right, and you're supposed to give 24 hours notice of that visitation, is that right?
Yes, ma'am.
All right, now you began having some problems with exercising that visitation at some point after that order was entered, is that correct?
Right after it was entered, yes, ma'am.
In our motion for enforcement, we've alleged 4 violations, 3 of them related to the denial, what you say is a denial of your visitation. Is that correct?
Yes, ma'am.
Okay, so the first one is a Thursday, January 2nd of 2020. Did you give notice that day that you would be exercising your visitation on Sunday, January 5th?
Yes, ma'am.
And how did you give that notice?
Everything's through email.
So you emailed, it is your testimony that you emailed Mr. Marlar that you would be exercising Sunday, January 5th?
Yes, ma'am.
Did you show up at the Sonic at noon?
Yes, ma'am.
And did you purchase an item at Sonic to show that you were present?
Yes, ma'am.
All right, and did you keep the receipt?
Yes, ma'am.
And did Mr. Marlar show up with Willow at any time while you were there?
No, ma'am.
How long do you usually wait for him?
I'll wait about 20 to 30 minutes before I sit there with my other kids and we wait.
Do you have any recollection of whether or not Mr. Marlar communicated with you one way or the other, saying he was going to be there or not be there at any time?
No, I don't remember, because most of the time I get no responses at all. He's cut off all contact.
All right. So do you usually attempt to text him while you're sitting there to see if he's coming? Or email him?
Yeah, pretty much begging him to see my daughter.
Okay. And so it's your testimony that on January 5th of 2020, which was a Sunday, he did not appear with Willow?
No, ma'am.
Okay. The next violation we've alleged is for a February 2nd of 2020 visit, which was a Sunday. Did you recall giving a email notice on Monday, January 27th of 2020?
Yes, ma'am.
And you said you would be there on February 2nd?
Yes, ma'am.
And did you show up at noon on February 2nd at the Sonic in Pleasanton?
Yes, ma'am.
And did Mr. Marlar show up for that visitation?
Yes. No, ma'am.
All right. And did you purchase an item at Sonic and keep the receipt to show you'd been there?
Yes, ma'am.
All right. And do you have any independent recollection of whether or not Mr. Marlar emailed you during the visit or communicated with you during the visit saying he would be there or not be there?
Now that I'm thinking about it, one of those visits may have been the time he showed up with Willow and he got upset at me after 6 minutes in the visit, and he took Willow after he cussed and screamed at me in front of her and my other 2 kids at the playground.
Okay.
No, I think actually one of those was the time.
But you're not sure which one of these it was?
No, ma'am.
All right. But you know you did not have your visit on February 2nd, Sunday, February 2nd from noon to 1.
No, ma'am.
All right. And then the third violation you've alleged is a February 16th of 2020. And that would have also been a Sunday, is that right?
Yes, ma'am.
And again, did you give an email notice on Tuesday, February 11th to Mr. Marler saying you would show up for that visit?
Yes, ma'am.
And you showed up at noon on February 16th at the Sonic in Pleasanton?
Yes, ma'am, with my 2 other children.
And did you purchase an item at Sonic to show you'd been present during that time?
Yes, ma'am.
And you kept the receipt for that?
Yes, ma'am.
All right. And did Mr. Marler show up with the child at that time with Willow?
No, ma'am.
So you did not receive your visitation on that date either?
No.
All right. Now there is one further visit that is not alleged in our motion, but we are allowed to add to that. So let me talk about, did you give a notice for visitation on Sunday, April 19th?
Judge, objection, Judge. I'd object on the basis that this alleged violation was not pled in the motion for enforcement, and therefore is irrelevant to the proceedings today.
Ms. Vickers?
Well, Your Honor, you're allowed to admit ongoing violations because usually by the time you get to court, there are other violations. And the Family Code allows you to add on continuing violations that are not specifically alleged in the motion.
All right, I'll allow the evidence not as an independent violation that Mr. Marler could be held in contempt for, but certainly to show a pattern of his behavior and character and what relevance it has on attorney's fees.
All right, Your Honor.
Only
And
objection.
so on Sunday, April 19th, did you email Mr. Marler on April 15th to attempt to exercise your Sunday, April 19th, 2020 visitation?
Yes, ma'am.
And did you show up at the Sonic in Pleasanton for the visitation on Sunday, April 19th?
Yes, ma'am.
And did you purchase an item at Sonic to show that you had been present for that?
Yes, ma'am.
And did Mr. Marler show up with Willow at that time?
No, ma'am.
All right. All right. Now, Ms. Monk, you were required to hire me to file this motion for enforcement to enforce your visitation. Is that right?
Yes, ma'am, because there were months we didn't get to see my daughter, but I don't have the receipts because I only have emails from him saying he wasn't going to be there. My siblings, we didn't see her for months.
All right.
We didn't see her my last visit, November 15th.
And what happened on November 15th?
We showed up with gifts for Willow, went to go sit down at the restaurant. We've had our last 11 visits at Mi Mexico in Jordanton. He decided that he was going to tell me where I needed to sit at the table next to him when all the prior visits I've had there, we sat at any table in the restaurant. He yelled in front of my kids. He yelled in front of Willow, humiliated us in front of the whole restaurant, and then we didn't get our visit.
All right, so.
Because we didn't sit at the table he wanted.
All right. And so you have continued to have some issues regarding exercising your very limited visitation.
Yes, ma'am. We don't get to see her.
All right. And you hired me and agreed to pay me reasonable attorney's fees to represent you in this proceeding.
Yes.
And you're asking the court to award you attorney's fees, reasonable and necessary attorney's fees, find Mr. Marler in contempt, and then award the attorney's fees. Is that right?
Yes, ma'am.
Would you agree at this point you've had makeup visitations for the ones we've alleged and the fourth one that was not alleged? You do not have a makeup visitation for the incident that recently occurred in November.
Yes, I don't have one for that, my last visit.
All right. And how long did that visit last before it ended?
About 7 to 8 minutes.
All right. And did Mr. Marler leave the restaurant?
Yes, with my daughter asking to please see her mom and brother and sister, and my kids crying.
All right. That's all I have, Your Honor. I pass the witness to Mr. Gear.
Mr. Gear?
Yes, Judge, may it please the court. Ms. Monk, you stated that on one of the dates of an alleged violation, Mr. Marler did show up with the child. Do you recall what that date was?
I need to go through my emails. There's several of them I don't remember off the top of my head. I have hundreds of emails to him.
Okay, but on one of these dates, he did show up with the child.
On another date, he showed up with Willow when he told me he wasn't going to be there. And I showed up just in case. And I think that was the same day he left with Willow. He got mad at me and he left.
Okay. Have you ever missed a visitation with Willow on your own accord?
Yes, in the very beginning in 2019, when all of this was happening, I missed a couple because it was hurting my daughter. I felt like it was hurting Willow because she didn't understand, because I raised her. She lived with me, her brother and her sister. Her whole life was changed just abruptly.
Okay, and how long did you not see your daughter at that time?
2 weeks, 2 visits, because I was scared of Mr. Mueller. I'm scared of him.
Have you missed any visitations recently?
No, my last one was September 5th. I sent him a notification 20 hours. I was 4 hours short of a 24-hour notice because we lost our phones. We had to get new phones. I told him I had the receipt from AT&T and everything. Somebody stole our bag with our phones in it, and he denied my visit the next day.
Okay, but 24 hours is just the minimum notice. You can give notice up to.
I usually give him a week, 2 weeks, right after the visit, I'll give him another notice.
Okay, and your visits are ordered to be supervised by Mr. Marler, is that not?
Yes, they are.
And on the incident in question that you testified to in November, you attempted to thwart supervision by going out of the purview of Mr. Marler with the child.
How come it wasn't an issue all the 11 times before? It's an
Objection,
open
unresponsive.
restaurant. He can see me everywhere in that small
And
restaurant.
there's an objection made. I'll sustain the objection.
But you do understand that your visitations are to be supervised by Mr. Marler?
Yes.
Okay. Nothing further, Judge. I'll pass the witness.
Your Honor, you should have gotten hopefully the emailed items by now.
I did.
All right, those would be the texts and the receipts from Sonic. They're together, each text with its receipt. We probably mailed it in one packet, but that's how they're set up.
Yes.
So I'd like those to be admitted. Okay, I'd like those to be admitted into evidence based on the stipulation.
Okay. No, I don't know what Ms. Cavazos has them. Okay. I'll admit them into evidence. I need to ask you, make sure you get a copy to the clerk or to the court reporter.
All right, Your Honor. We can try to get it, maybe a direct email address, or we'll figure that out. All right, Your Honor, I'd like to testify as to attorney's fees.
Go ahead.
All right.
I swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth.
I do, Your Honor. Ms. Monk retained me in this case, and I filed a motion for enforcement. I was retained. She first consulted with me on December 30th of 2019. And we consulted for an hour over the course of the next few months. We talked about the violations. I began drafting the enforcement. I had her produce the documentation that we've admitted into evidence. COVID hit, which slowed down this process somewhat. I had we set it. I had Mr. Marler served. During some of this, I also talked to the lady who runs the daycare where she was, Ms. Herrig at Shining Stars. I had some conversations with her. We ended up having to reset this hearing. Mr. Gear got retained and we reset it. We had several emails where we did Rule 11s, resetting this case a couple of times, and we did work out some makeup visitation. We've had some other issues that we've spoken about and emailed about over the course of time. I've drafted, like I said, a couple of emails and Rule 11s that we have e-filed. I also, as of the last court date, which I believe was last week, I sat there all day. Judge Ellison did not reach us. We sat there till 4:30. I had 2 cases set that day, and they got both reset to today. I haven't even counted that time period in this calculation, but I'm an attorney licensed and have been licensed in Texas since 1985. And I primarily practice in Atascosa and surrounding counties. I have done family law quite a bit for most of my career, and it probably makes up over 50% of my private practice. My current hourly rate is $250 an hour, which is reasonable and necessary and well within the range of attorneys of my experience charge what they charge. Without counting last week's hearing, I spent 18.45 hours in this case, which is attorney's fees of $4,612.50. If I add on 4 hours, if I take the 8 hours I sat around in court last week and we didn't get reached, and I divide that in half between the 2 cases, that's another 4 hours. So that's another $1,000 to add to this to get us to today. And of course, today's hearing is probably another 30 minutes. But at this point, even without today's hearing, I'm at $5,612.40 in attorney's fees, which I feel in this case is reasonable and necessary. We'd ask that Mr. Marler be held in contempt. And having done the makeup, we would ask that he be admonished as to continuing to honor what this court has ordered. My client has very little visitation. And so missing one of these is other than the normal case, is a big deal to her. So we would ask that you award attorney's fees in this amount and make them enforceable as part of the contempt and in my own name. So I'm open for cross-examination by Mr. Gear.
Right, Mr. Gear.
Yes, Judge, may it please the court. Ms. Vickers, of those 18.45 hours, would you have any idea how many of those hours were incurred prior to July 10th, 2020?
To July 10th, 2020. I would have to add them up because I don't have it. Wait, actually I do. 10.4.
10.4?
Yes, sir.
And those are the amount of hours on July 10th, 2020. That was the date that we entered into a temporary orders regarding the violations in this matter. Is that correct?
That's correct.
And the only thing that that we left remaining were the contempt findings and the attorney's fees. Is that correct?
Let me see. Yes, there was a lot of communication with you. I had to draft the order. I drafted the temporary order. I emailed you all the pleadings. You and I've had numerous conferences and email exchanges regarding the case. There's been some other things besides just the attorney's fees, but that's what's left for today's hearing.
Okay. Nothing further, Judge.
I have nothing further to present, Your Honor. We rest.
Mr. Gear?
Yes, Judge. I'd like to call Mr. Chad Marler.
Right, go ahead.
Mr. Marler, would you please state your full name for the record?
Chad William Marler.
And Mr. Marler, you are the custodial parent of Willow Grace Marler. Is that correct?
I am.
And you are a party to the order that was entered in July of 2019 regarding possession and access of the child. Is that correct?
I am.
And how consistent has Ms. Monk been in her visitation of the child?
Not very. At first, she wasn't consistent at all. She uses the visitation of the child as a means to harass me. she has, since she's retained Mrs. Vickers, she's gotten more consistent. She's done things that she was ordered to do by the original orders, such as pay her child support that she was delinquent on for the first 6 months. But other than that, a lot of the things she still hasn't done from the original order. She hasn't got a mental assessment. She hasn't done a home study. She has made up her child support and continued to pay her child support, but it's very little and not nearly enough to cover the cost of supporting the child.
Okay. And how much do you receive in child support?
$181 and some odd cents a month.
Okay. In regards to the violations, tell me about the violation that occurred on January 5th of 2020. Did you actually receive actual notice of her intent to visit?
January 5th? I do not know. I'm actually taking a break from work right now. I don't have my records in front of me. What I can tell you is that prior to February, at the end of February, I was working oil field, so I'd work 2 weeks on, 1 week off. I have several emails stating that if I couldn't make the visitation because I was out of town or at work, that I would make them up to her. My wife had started doing the visitations in lieu of me so that Mrs. Monk would get her visitations, because we knew this was going to be an issue, because she was never cooperative about doing the makeup visitations.
Okay. So between Ms. Monk's prior inconsistencies and engaging in visitation and your work schedule, it added some complications to the visitation schedule. Is that correct?
Yes, it has, but we've worked that out because my wife has picked up the slack where I have a problem meeting it.
Okay. And you've always been willing to make up all these alleged misvisitations. Is that correct?
Yes. In fact, what I was to understand from the previous agreement, that if I was willing to give her 4 makeup visitations, to make up the days she said she missed, that would be in lieu of Mrs. Vickers' attorney's fees. That was the direct understanding I had, that if we gave her the 4 makeup visitations, that would keep us out of court and there would be no need to pay Ms. Vickers her attorney's fees.
Okay. And we did make up those visitations for Ms. Monk. Is that correct?
Yes, we did.
And you have complied with the order in all aspects that they requested in their motion for enforcement. Is that correct?
I have complied.
Okay. You heard Ms. Vickers testify as to $4,600 in attorney's fees plus. Do you feel that that's what's your opinion as to the reasonableness of those fees?
Well, I feel it's excessive. I feel Mrs. Vickers representing Ms. Monk is an issue in itself. I don't feel Ms. Vickers is acting morally or ethically. Seeing how Ms. Vickers is the attorney that dropped the case on her, the criminal case on her, for a no trespass order. Last year, the entire year, I was trying to correspond with Ms. Vickers' office to find out what was going on. Being the victim in that case, nobody from her office would talk to me. So I found out, and I only found out through Ms. Monk bragging about it, that Ms. Vickers dropped the criminal trespass violation on her and then picked her up as a client in family court.
Okay. Back to the violations. They also requested some information. Have you turned over all that information to Ms. Monk?
Anytime Ms. Monk requests information, I give it to her.
Okay. In a timely and reasonable fashion?
Expedient fashion.
Okay. And so are you asking this court to deny the motion for enforcement and deny the motion for contempt?
I am.
Okay, and are you asking the court to deny that based on the fact that you have indulged in allowing Ms. Monk additional visitations to remedy the visitations that were missed?
Not only that, I'm also asking them to deny it in the fact that we had a previous agreement that if I made up the visitations, that would be in lieu of Mrs. Vickers' attorney's fees. So yes,
Now,
I am.
you speak of a previous agreement, but I don't understand what you're talking about.
When I hired you, when I came down last summer from Michigan, when I was working out of town, I hired you. We worked out a deal with Mrs. Vickers' office that if I gave her the makeup dates, it would keep us out of court, and that would avoid paying Ms. Vickers' attorney's fees.
Your Honor, I'm going to object to that. No such agreement exists anywhere in writing or any place else or verbally.
All right.
I'll cover that, Judge.
I'll give Mr. Gear a chance to develop this, but I mean, obviously.
Thank you.
It requires agreements to be in writing.
Mr. Marler, in regards to the July 10th, 2020, and this may be a misunderstanding between your counsel and you, that we did agree, you were forwarded a copy of the agreed temporary orders to review and approve that stated the dates and times that the makeup visitations would occur. And it also stated that the contempt findings and attorney's fees would be reserved for a final hearing in this matter.
Maybe I did not understand that.
Okay, but you recall receiving the agreed temporary orders?
Yes.
Okay. Nothing further, Judge. I'll pass the witness.
Ms. Vickers?
Mr. Marler, did you allow Ms. Monk to have visitation on Sunday, January 5th of 2020 between noon and 1 p.m. at the Sonic?
I cannot tell you whether I did or did not. I do not have that information in front of me.
All right. Did you allow Ms. Monk to have visitation on February 2nd, Sunday, February 2nd, 2020 at noon at the Sonic in Pleasanton?
What were the dates?
February 2nd of 2020, Sunday, February 2nd from noon to 1 at the Sonic in Pleasanton.
Again, I can't answer that question. I don't have that information in front of me, but it seems to me that these are the dates that were in the original agreement that we would make up.
All right. And then do you have, is it your same answer for the February 16th, 2020 visitation? You're not going to be able to say whether you allowed it or not?
Yes, I would assume so.
All right. Your Honor, I have no further questions of Mr. Marler.
All right, Mr. Gear?
Nothing further at this time, Judge. Rest and close.
All right. I'd like to know from Mr. Marler if he's had a chance to look at the text messages that were admitted into evidence.
No, I have not.
I had emailed those to Mr. Gear, I would say some weeks ago, all of them. I produced those to show him to support the allegations in our motion. I don't know if Mr. Gear communicated those to Mr. Marler, but he's had them for some time.
Judge, yes, Judge, we received those exhibits, I want to say prior to entering the temporary orders. I believe they were emailed to Mr. Marler. I'll look at my records to check. I know Mr. Marler sent me a bunch of information as well. And I think it's in response to that.
I guess what I want to know is, Mr. Marler, there are several long text messages from Ms. Monk to yourself complaining that visitation was not allowed and giving you notice of upcoming visitation. And what I want to know is, did you ever reply to those text messages one way or the other?
I can't, like I said, Judge, I can't answer that honestly right now. I don't have the information in front of me. What I can tell you is that Mrs. Monk would text message me endlessly. So, some point, I quit having any kind of communication with her via text and only did it via email.
And are these texts or emails?
They're emails, Your Honor.
I'm sorry, they're actually emails.
Yes. And I know they're not in the greatest form. That's the way I received them, and that's as legible as I could make them. And I know they cut off, but it has the important information is visible in the email.
Okay. Mr. Monner, did you ever respond back to Ms. Monk denying that you had denied the visitation periods?
Oh, I'm sure I did, Judge. There has been several times, like I said, there has been several times in some of these dates where I was still working at Forbes Energy, where I was working a 2-week on, 1 week off schedule. I mean, I've got several supporting emails stating that I would make up visitations for her that I missed. You know, I don't have them in front of me. I would have to pull them up. I didn't realize that this was going to be an issue.
Okay, and what transpired at the Mexican restaurant where Ms. Monk related that you objected to where she wanted to sit? Did that happen?
Your Honor, in the order, it states that I'm the monitor of the supervised visits. And as of recently, you know, I would let her sit across the restaurant and keep her distance from me because me and Mrs. Monk don't really care for each other. So after several months of this, you know, my daughter started telling me things like she was going to go live with her mom and do these
I'm going to
other
object, Your Honor. That's all going to be hearsay. Anything his daughter said to him is hearsay.
Well, I didn't ask. I'll overrule the objection. I'm just wanting to know what happened.
When we got there, I told Mrs. Monk, we usually get there before she does. I told her, I said, look, I said, as per the court order, I'm the supervisor. And if you're sitting across the restaurant, I can't see you and I can't hear you. I said, so I have a table. It's a reasonable distance. It was about 10 foot away. I said, you guys are more than welcome to sit there. You know, and Mrs. Monk immediately took off across the restaurant, sat down at another table. So I got up, I went over there, and I asked her, I said, look, you know, we got to play by the rules now. You know, you drug me back into court over this stuff. So the rules are the rules. I'm to supervise. So please sit where I asked you to sit. Or find another reasonable place to sit. But I need to be able to see and I need to be able to hear. And she refused. So we got up and we left. My wife even went over there and asked her to comply. My wife was in tears. Willow was in tears. She brought gifts. She was the one that was yelling. She was the one that was being rude. Her children were not in tears. In fact, her children are used to her behavior. Mikey tried to give the gifts to Willow, and then she came out and snatched it out of Willow's hands and said, not all that in there is for Willow. She can't have it now. She'll get, in fact, she said specifically, she'll get the gifts when her daddy decides that we can have our visitation.
All right. Anything else on the other side?
Obviously, Your Honor, my client's testimony was different than that. And at this point, we don't have anything further to present.
No further evidence, Judge, just closing statement.
Go ahead. I guess Ms. Vickers is the movement.
Well, Your Honor, it appears obvious from Mr. Marler's own testimony that you elicited just now that as my client testified, for 11 visits at Me Mexico, they sat across the aisle or in the restaurant. It's not a real big restaurant. It's open. It's not, I mean, I don't know where you would go to quote unquote hide, but my client testified she was in view of Mr. Marler, and this is the first time this has ever happened. It appears to me from Mr. Marler's testimony that he's mad because she wanted to ask for attorney's fees in the enforcement and wanted to proceed to this. Because in his mind, he did the makeup visitation. We're done. I don't owe you any attorney's fees. Well, unfortunately, my client is under a very strict order, and his work, his being out of town has nothing to do with it. He is required to obey the court order unless there's an agreement otherwise. And now at this point in time, after she had to hire me to enforce it to get the makeup visitation, now he wants to say, well, I would have given her that if she just asked me. Well, I'm just going to say to you, Your Honor, that never would have happened. And the only reason we've managed to get the visitation is because of the enforcement. And Mr. Marler is in contempt. There's no evidence to indicate, contrary to my client's testimony and the evidence before you, that he allowed the visitation. It's really obvious that under the evidence presented, he violated the court order and denied her the limited visitation he has. And she was required to hire me to do the enforcement, and he should be held in contempt in order to pay some fees to reimburse her for that. I've testified to those fees. That's what we asked this court to do. I mean, the work is what it is. This has been ongoing for months now, and I've testified to in great detail as to the attorney amount of hours and time I've spent on this case. So we'd ask you to hold him in contempt, admonish him about obeying the order, and award attorney's fees as requested.
Mr. Gear?
Yes, Judge. May it please the court. Judge, we would argue that the prior order is unenforceable by contempt in that it's ambiguous, not clear and specific enough in its terms. Basically, it only says 24 hours notice. It doesn't say specifically how that notice is to be given, whether it's by text, email, phone, what have you. So we would argue without that specificity that any notice is deemed insufficient because it's not specified in the order as to how that notice is to be given and received. In regards to the attorney's fees, we would argue based on the, we understand 157, 167, but the key word there is reasonableness. We believe that these attorney's fees are significant in regards to 3 violations of 1-hour visitations, all of which have been made up by agreement. We would argue that the evidence regarding the attorney's fees is insufficient as to a lack of the minimum requirement of an itemized specified documentation of these attorney's fees. If the court is to award attorney's fees, we believe that they should be in accordance with the motion and work done up to July 10th, when we did actually agree to remedy the violations by makeup days. And we request no attorney's fees be awarded, that Mr. Marler not be found in contempt because of the lack of specificity as to the notice requirement. But in the alternative is if the court is to award attorney's fees, that it be a minimal amount. Thank you.
All right, I'll just note that this was a default judgment that Mr. Marler took. So the notice provisions were drafted specifically by and solely by his attorney. 2, will hold Mr. Marler in contempt for not allowing the 3 visits, but I am not ordering any coercive jail time for that. I am going to impose attorney's fees. Before I do that, I want to talk to both parties. There's 2 ways that you can behave when you're trying to work out under a order with access to children. You can either work with each other and be reasonable, or you can hold each other's feet to the fire and do exactly what you're allowed to do or required to do by the order and not a bit more. And I'll direct this primarily at Mr. Marler, but you have to pick one or the other, sir. You can't say, oh, I've got all of this power and I'm gonna, use it to absolutely restrict Megan Monk's access to the child. But then when it suits me and when it makes sense to do something different, I can say, hey, let's all be reasonable. Let's Rodney King it. Let's just all get along and work around this and decide to make up visitation differently without getting attorneys involved. It's one or the other, okay? And I'll say that for Ms. Monk too. It's one or the other. I hope that you all are able to work things out without an attorney's intervention or assistance in the future. but I will award the petitioner attorney's fees in the amount of $4,000. If you will prepare an order for that,
How much was it, Your Honor?
4,000 even.
All right, I just want to make sure I got that. All right, thank you, Your Honor.
Okay, and Ms. Barrera, the final order you sent me, I was just downloading everything that you'd sent along. The final order that you sent me was corrupted. That's a Zoom problem. It could be a problem with my computer. I'm downloading something else right now. That's your petition. Let me see if I'm able to open that up. No, okay.
You want me to email them to you?
No, I am going to make Norma the host. And I've learned from bitter experience that once this starts happening, it snowballs and more things will stop working. So I'm going to make Norma the host. I am going to leave the meeting and reboot my computer. Last time I did this, it took 15 minutes or more, but it was installing an update. Hopefully it's not installing an update, and I'll be back in 7 or 8 minutes. But again, I'm going to reboot my computer because, like I said, as I found out, once this starts happening, it snowballs and nothing works after a while. I'm going to have to reboot it anyway.
Okay.
Judge, may I
Your
be
Honor,
excused?
Yeah, Mr. Gear and I be excused and our clients? Okay, we're leaving the meeting. Leave the meeting. You can leave the meeting. She's still on it. Megan, you can leave.
Chad, you can leave. I'll be in touch.
All right.
Okay, I'm back. And if we still need to have a hearing, I'm going to ask the attorneys to send me whatever documents I need to look at. The ones that came earlier from Ms. Barrera were the corrupted, the PDFs were, the JPEG was fine.
Do you want to send those in chat, Your Honor?
Please.
Do I need to resend them in a different format, or was it just that time?
I think it was just a Zoom problem. Hold on just a minute.
Okay.
Russell Wilson? All right, I'm sorry. I had officers calling about search warrants.
Sorry, Judge. The first two I sent
All
you,
of these.
you can ignore the first two. They were the old enforcements. I'm sorry, I was in the wrong file. The motions for enforcement, that was already heard. So it's just the final order enforcing the file stamp petition and the child support payments.
Okay. We need to have parties sworn in.
Yes, Your Honor.
Yes, Your Honor.
Am I muted? No. We need to have parties sworn in.
Yes, Your
Yes,
Honor.
Your Honor. Can you hear us?
All right, hold on a second. Okay, I'm sorry. For some reason, my computer muted itself. So I saw you speaking. Do we need to have parties sworn in?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right. Mr. and Mrs. Brand, would you raise your right hands? Do you, and sir, your microphone is muted?
Lorena, yours is muted.
Yes.
Mr. Bryan, yours is still muted.
Each of you solemnly swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. And your name, ma'am?
Lorena Bryan.
Your name, sir? Your name, sir?
Christopher Bryan.
All right. Go ahead, Ms. Barrera.
Your Honor, just a little bit of background. We had initially filed a motion for enforcement back in November of 2018. We had reset it throughout the year to get some compliance, agreements of compliance and stuff. It was finally heard in October of 2019. You suspended commitment to see if a lump sum payment would be paid. Mr. Bryan came up with that. And so in January of 2020, you issued an order enforcing the child support, suspending commitment, 180 days commitment suspended for probation. Since that time, Mr. Bryan has made one payment in March of 2020, and then there was a stimulus check payment received recently in September. But since that time period, he has not paid the regular child support of $507. And then there was an arrears judgment issued in January of, there was a judgment of $11,000 for prior arrears, and you had a $100 payment towards that. So those payments have not been made also. So we're asking to revoke his suspended commitment and to commit him to the Karnes County Jail for a sentence.
All right, Ms. Tapia?
Your Honor, my client agrees that those payments have been made. I have submitted 2 other payments that were made directly to Ms. Bryan via PayPal of $280. That was towards child support. Basically, our argument would be that he's still seeking disability based on the conditions he had testified to previously. That was held up due to COVID. In addition, they had gone to the OAG's office seeking to modify the child support. And I even had to send a letter to the OAG because they kept telling them that you have an attorney, you have an attorney. They never filed anything. I subsequently last night filed a motion to modify the child support to be within the guidelines based on minimum wage. And we're asking that the court allow Mr. Bryan to try to come up with the money to continue the payments. He does have 2 other children with his current wife, and he is moving forward with the disability. Those things with his condition with regard to his vision, sleep apnea, narcolepsy, they are not precluded from disability. It just goes under a different, it's not an automatic, but there are breathing, respiratory, and cardiac conditions that are associated with those. And he still is allowed to pursue his disability claim. It's just that it's taking a little bit longer than expected with COVID. He's doing the best he can to try to make the payments and try to help out as he can. He has not seen the child since we were back in court in January. Ms. Bryan has withheld visitation from—
Your Honor, I'm going to object. That's not before the court, and I would say that's not true, and that's not before the court.
We're asking that the court, based on his health conditions and the fact due to the delays with regard to COVID, the AG's office not assisting them, that he be allowed to continue and to try to make those payments until we can get them modified to where it's within line to minimum wage standards. And then those arrearages will be just rolled into the new payment.
Okay, and how much was supposed to be paid on the.
It would have been February 1st would have been the first payment due. It would have been a total of 607. And then there was a payment in March for 507. And then thereafter, there hasn't been a payment since the stimulus payment of 1,200.
There's actually a payment in March of 607, which is the
Sorry, 607.
the arrearages plus the child support payment. And then there was the $1,200, the stimulus check that was taken. And my client also claims that there was another $280 payment via PayPal that I submitted in chat that was for child support.
And Your Honor, you had heard all these medical issues before, and there was throughout the year and a half that we waited to hear that case, there was no medical evidence provided, documentation of any kind or any doctor testimony provided when we finally had our hearing. So I don't know.
Okay, and I will recollect that. Give me just a moment. All right, I guess your first witness.
I'll call Ms. Bryan.
All right, go ahead.
Lorraine, okay. Ms. Bryan, could you state your name?
Lorena Bryan.
And you're the mom of Rylan Bryan, is that correct?
That's correct.
And you heard me about the timeline. The judge signed an order in January of 2020 regarding your motion for enforcement of child support, is that correct?
That is correct.
And according to your payment history, he's made to the Attorney General, he made that payment of 607 around March, and then you didn't receive another thing until the stimulus payment was received in September, is that correct?
That is correct.
Now he had sent you, I guess by like a PayPal app or something, I think a payment of $200 in August and then an $80 PayPal app. What were those for?
I made contact with him. They were me asking him to help me out, with my son's school items, just necessities as well. He's never made payment, constant payment. And that money was money that I had to reach out to him, to help me out, because it's never been, anything constant. So that's what that was for.
Okay. And you had already waited almost a year to have your enforcement hearing heard, is that correct?
Yes, ma'am.
What's your current situation in regards to having income and being able to support your son?
At the very moment, I'm unemployed. I am a student, full-time student. I will be graduating here within 3 weeks. And I'm living off of my previous employment, and my parents are also helping me out. At the moment, that's what's happening.
And what was your kind of line of work before, to remind us?
Law enforcement. Been in the line for 10 years now, since 2010.
Okay. And is that the same kind of job you're looking towards to get after graduation?
Yes, ma'am.
So are your income and sources limited in regards to helping support your son?
Yes, ma'am.
And what are you asking the court today to do?
I just want them to really look at this. I've never asked, never lived off any type of child support. Currently, like I said, I'm not employed, and just trying to better myself and my future and my son's future. And I just want them to really look at this, and I want him to make sure Chris takes responsibility for what he is supposed to be doing. Having to make adjustments and all this it's very unfair. It's like me asking my son, okay, well, you're gonna have to wait to eat, you're gonna have to wait, for clothes, you're gonna have to wait for, all these things, and it's just completely unfair. It's not right. And I'm just tired of going back and forth through this court thing.
And did you have to borrow, or did somebody help you with money for my fees to bring this action?
Yes.
And are you going to have to pay them back for that?
Yes.
And no further questions, Your Honor.
Tapia?
Thank you, Your Honor. Ms. Bryant, you stated that you've been in law enforcement for 10 years.
Yes, ma'am, that's correct.
Who have, who have you worked with?
I've in 2010, well, actually in 2008 to 2010, I received my degree in law enforcement. Started in 2010. I worked in corrections detention. I was also a supervisor in the field facility, GO, contracted through ICE. And then came to the sheriff's office in Barrett County. And then I'm currently going to be receiving my license here within 3 weeks.
So when you went to the sheriff's, I believe last time we were in court, you had just finished, I thought you'd finished the academy.
That is the Sheriff's Academy. I'm receiving a license through San Antonio College at the moment.
And a license for?
Peace officer license.
Okay. And why, when, so the first payment that was received after we were in court last time was March 9th, is that correct?
Yes, ma'am.
So why did you wait over 9 months to bring an enforcement action?
To be completely honest with you, I just wanted to see if he would, take responsibility. I didn't want to, just wait 2 months and be like, all right, well, he hasn't, paid, he hasn't done anything. It's not easy for me either. I have to be, I have to pay for my attorney. He obviously gets, you were appointed for him or whatever. This is free, I'm assuming. To me, it's not free.
Your Honor, non-responsive.
That's why I waited, to give him a chance. And clearly.
Ma'am, there was an objection. I'll overrule the objection. Your next question.
Thank you, Your Honor. But your previous claim was that he had never done anything before. So you were waiting 9 months to see if he was going to do something?
I'm trying to believe it or not, I'm trying to see if he helps. Like I said, it's not easy. Yes, I did wait. In the meantime, I was reaching out to him. I have reached out to him, asked him, hey, can you help me with my son needs shoes or he needs this. I have reached out to him because I wasn't receiving any payment. And it's always.
And wasn't there, didn't they make an order for your son's school supplies from Walmart back in August, on August 16th?
Yes, they did. I asked for him to help me, and yes, they did. They didn't even go by a list or anything. They just assumed what he would be needing for class. This was, for his freshman year, which currently he is in. I did not pick up the order due to, it was more like a slap in my face because it was like markers, things that maybe a kindergarten would use, not a freshman in high school. And that was a reason. And my parents ended up helping me before getting him, the stuff that he was going to need for school. So I went ahead and took my parents' help.
So what high school is he attending?
Goliad High School.
Where?
Goliad High School.
Goliad, thank you.
Okay. And you live in San Antonio?
Yes, ma'am.
Okay. And would the list of what's needed, isn't that published on the school website?
No, ma'am, it's not. In high school, they have to, they usually tell them the first, second day of class. I did explain to him though, I told him more or less what I think that he would need like pens and spirals and binders and stuff like that I know for a fact that he would use. And instead, like I said, it was things that he wasn't even gonna need.
Okay, so he
was
would
like
need
10 items, maybe 10 items.
markers
so.
and folders and things like that. Is that your testimony, that he wouldn't need things like markers or folders or anything like that?
There was other, I'm not saying he wouldn't need them completely. What I'm saying is there would have been more important things like spirals, binders, paper, pens. It's common sense, in high school.
But because you felt that was a slap in the face, you didn't go pick it up? Or
not only that, like I said, I also reached out to him and I told him what he would be needing. And instead of getting him what I knew for a fact that he would need, he went and purchased things that wouldn't even have helped.
Okay. And you currently live in San Antonio, is that correct?
Yes, ma'am.
Okay. And so when do you see your son?
Every weekend. Fridays, Saturdays, and Sundays. School is Monday through Friday.
And to pay for school, do you have student loans or?
Excuse me?
Do you have student loans to pay for school?
I don't at the moment, no.
So how are you paying?
My parents have helped me out.
Okay, and they pay for your living expenses and everything in San Antonio?
No, ma'am. Like I said, I'm living off currently for my previous employment. I do know how to manage my money, so I did save, you know, and that's what's helping me out. And like I said, I will be done in 3 weeks. So.
And how long was the school program?
It started in May 4th. I will be graduating December 17th.
Okay, and when were you laid off from the sheriff's office?
It's been like 2 months, maybe.
And was that just a work reduction or?
It was a lot. I was having to work a lot of overtime. When I started attending school, I went to night shift. Before that, my hours were 2 to 10. And then I went to night shift from 10 to 7 in the morning, or 11 to 7, I'm sorry. And it was just getting too much. I was having to work overtime, and I was maybe getting like 30 minutes to an hour sleep from work, overtime, and school. And that was one of the main reasons I decided to just focus on school.
So did you resign or were you laid off?
I talked to them about my situation, and it's a better choice. No, I was not laid off.
Okay.
Our hours were 8 hours with overtime. It was a total of 16 hours a day.
I have nothing further. I'll pass the witness, Your Honor.
Ms. Barrero?
I have nothing further, Your Honor.
Okay, your next witness?
I'll call Mr. Bryan.
Go ahead.
Mr. Bryan, you had heard me do their opening earlier where you were aware that the judge did a final order of enforcement on January 22nd, 2020. Is that correct?
Yes, ma'am.
And you were ordered at that time to pay $507 for your regular child support and $100 to your arrears payment every month. Is that correct?
Yes, ma'am.
And you're aware that you were sentenced to 180 days, and that sentence was suspended in contemplation that you would comply with the judge's order. Is that correct?
Yes, ma'am.
And the first month after this order was issued in February, you failed to make the child support payment or the arrears payment. Is that correct?
Yeah, but I've been trying. I have been trying.
Is there any type of payment that was made, like $20 or $10 that was made in the month of February?
In the month of February? No.
Now, you did make a payment in the month of March for the $507 and the $100 payment. Is that correct?
Yes.
And from then on, a payment to the Attorney General by you, not from the government through a stimulus check, has not been made. Is that correct?
Correct.
Your Honor, I think somebody's telling him, I hear somebody's speaking in the background telling him what to say.
All right, Mr. Briand, who all is with you in the room?
My son and my wife.
Okay, I'd like to ask them to leave, or at least step back out of, cannot whisper to you.
Okay.
So you did not make a payment to the Attorney General for what was ordered in April of 2020. Is that correct?
Correct.
And you did not make a payment in May of 2020. Is that correct?
Correct.
Not make a payment in June, July, August, September, October of 2020. Is that correct?
No, it's not.
Did you make a payment, not the attorney, not the government, through a stimulus check? Did you make a payment to the Attorney General?
Not to the Attorney General, no.
Okay. And then in
it was directly to her.
In this month of November, did you make a payment?
Month of November. No, I haven't. Not for November. Not at the moment.
Now, the 2 payments by PayPal of $200 and $80 that you sent to her directly, you're aware that the order states you must send any actual child support payments that are to be considered child support payments through the Attorney General State Disbursement Unit. Do you understand that?
She told me that she wanted it directly to her.
Okay. Do you understand that the order said you're supposed to pay the disbursement unit any child support payment?
Yes.
I have nothing further, Your Honor.
All right, Ms. Tapia?
Thank you, Your Honor. Mr. Bryan, with regard to the $200 and the $80 payment that you just testified that you made directly to her, why did you make it directly to her instead of to the child support disbursement unit?
Because she said she wanted it directly to her.
Did you advise her that it needed to go through the disbursement unit?
I didn't know, honestly.
Okay. So you just agreed to make it through PayPal, is that correct?
Yes, ma'am.
And was that payment for school supplies or clothes, or was it your understanding that was for child support?
It was for child support or for help, whatever I can help her with.
Okay. And then your understanding at the time when those payments were made back in, I believe it was August. Yes, in August, those PayPal payments. As far as your understanding, was Miss Bryan unemployed, or was she?
I did not know she was unemployed.
Okay. And where are you at currently with your disability application?
I have court next month for a hearing.
Hey, Mr. Bryan,
William, do you still have
Bryan
somebody whispering to you?
cannot be back there.
No.
Okay, so you have court next month?
Yes, ma'am.
Okay, and what do you know a hearing with regard to what?
For my disability, see if they're gonna I don't know how to explain it.
Approve it?
To approve it, yes, ma'am.
Okay. And and did you seek out the Attorney General's office to help you modify the current the orders with regard to child support?
Yes.
And what did they tell you?
Your Honor, I'm object to hearsay.
What were you?
And I don't even know if it's relevant.
Okay, I'll allow the question, overrule the objection.
Thank you. Go ahead and answer, sir.
They said they couldn't help me because of that I had an attorney already.
Okay. And back in December, I forwarded to you and the Attorney General's office advising them the scope of my representation of you. Is that correct?
Correct.
Okay. And even with that, they still refused to help you?
One lady said she was going to help, and we did make a few phone calls, and for a couple of days, she said call her in 3 days, 4 days, something like that, and she was going to help us out. Then we wound up not hearing nothing, and then they told us, we went back to the Attorney General, and they said they couldn't. They then again said that they couldn't help us again because we had you as an attorney.
Okay. And then we just filed a motion to modify the child support that was accepted today by the district clerk's office, correct?
Correct.
Okay. And so currently, you are currently unemployed, is that correct?
Yes, ma'am.
And did you file taxes for 2019? Did you personally file taxes?
No, I'm gonna do that this year.
This year,
do this, ma'am.
Okay, so And so currently, the only income coming into your home is whatever your wife Sonia makes. Is that correct?
Yes, ma'am. Can I say something?
Now, let me ask you a question. If the court were to allow you to make, so currently you're claiming that in our response that the arrearages from February to present are $3,376. You're asking for the $280 credit for the payment you made in August to her on PayPal. Is that correct?
Yes, ma'am.
And if the court would allow you to come up with a lump sum of approximately $1,500, you'd be asking the court to allow that, and with the modification of your payment, allow those arrearages to get rolled over into the new payment that would be ordered under the modification. Is that correct?
Yes. We've been trying to modify before the last judgment was made.
I understand. And you currently have 2 children with your present wife. Is that correct?
Yes, ma'am. 1-year-old and well, he's gonna be 2 next month, and my daughter's gonna be 1 next month as well.
Okay, and you help your wife with the care of the children?
Yes, I do.
And what current medications are you on?
Oh, there's there's Levemir.
What is that for?
That is for my sugar, I believe. Then
Your
I got
diabetes?
yes, ma'am, my diabetes. Then well, I have my sleep apnea machine. I take I don't know, right? I don't know the names right off my hand right.
All right, sir, you need to start over. After
Uh,
sleep apnea machine, you broke up.
Oh yeah, okay. My sleep apnea machine. Then I got what are my other medications? Can I have a piece of paper? Yeah. I take Adderall. I take 30 milligrams of that. And I take my pump machine when I can't breathe.
What do you mean by pump? Is it like
It's
an
an inhaler.
inhaler?
Yes, ma'am.
Okay.
Um,
Do you know what's in that? Is it albuterol or?
I think yes, that one. And yes, I take metformin.
What
I
is
take
that for?
that one's also for my diabetes. And I take I don't remember all the names of them. Is it? I need to ask my wife about those names. I forgot all of them. The rest of
But
them.
what conditions do you take medication for? Can you remember it that way?
Yes. My sugar, my diabetes, my sugar, high blood pressure. I get acid reflux. My for my was it my mind? I'm getting depression. I'm taking my depression medicine. I
Okay.
take what's the other one? There's oh man, what else? There's like 2 or 3 more. I can't really
Okay.
remember that.
Do you know if you've been advised by your doctors, if because of your condition and your medications and everything, that if you are you at a high risk for if you were to catch COVID?
Yes, I am.
Okay. All right, I have no further questions. I'll pass the witness.
Ms. Barrera?
And there's nothing further, Your Honor.
All right, sir. What attempts have you made since April 1st of this year to secure a job, to get employment?
I've gotten, I haven't gotten any because the doctor had given me, put me on doctor's care. And then I talked to Social Security and they told me if I would make an attempt that they weren't going to help me attempt to find a job. But my wife's the one that's been doing everything, trying to help me out and help Lorena. And my vision's going bad. I can't see that good. My driving too, I'm not allowed to drive either due to narcolepsy.
So the answer is none.
Just whatever we've done so far, sir.
Okay. What day is your appointment for your hearing?
I
So
think
you had a Social Security Administration hearing?
it's in December. I think it's December 14th. Yes, December 14th.
Okay, do you want to, that's on a Monday. Do you want to clarify that?
I think December 14th. Can I ask?
Yes, ask whoever you need to ask.
Okay, thank you, sir. Wait.
When's what?
My December.
Papers are in the house. It's in December, I think, second week of December or something like that. I gotta go, it's your paperwork's at the house.
Okay, she said this. She thinks it's the second week of December. All our paperwork is at our house, and right now we're not there.
Okay, hold on a second.
You still need me? Do they still need me?
I hope. I don't think so.
Okay, so where are you right now?
Currently I'm at my mother-in-law's house.
Okay, anything else for this witness?
Just a couple questions.
Yes, ma'am.
Mr. Bryant, do you own your house or are you renting your house?
We're renting, but they pay us to stay there because because we can't afford the rent. So we get a check of I forgot how much. They just sent us our first check the other day. Every 6 months it's $87.
Okay.
And they just started that.
Okay, so you don't pay rent.
Section 8? Go ahead, Ms. Pereira. Do it on this minute.
So you don't pay rent, or they pay? So they pay the rent for you and give you a check every month?
They pay us for the 6 months. They do pay us, yes. And what was the other question you said?
So they pay your rent plus you get an additional check every month?
Yes.
Okay.
Well, they don't. It's every 6 months.
And have you done anything to try to borrow money to pay your child support?
I have, but I owe them still from the last time I borrowed the money. And I have someone that's willing to help me pay the rearages, but it's not going to be much. It's only going to be $100 a month. But they're willing to give their debit card and give the number to whoever they got to give it to so they can help me out. And they could just automatically pull out each month.
And have you gone to Texas Workforce Commission or any disability workforce commission to get employment?
No, I didn't. I wasn't. They told me I wasn't allowed to look for any type of job or look, because if not, I wasn't going to go through my my disability, Social Security.
Nothing further, Your Honor.
Ms. Tapia?
I just wanted to clarify, you said that you get a check from the housing, you get one check every 6 months or a monthly check?
One check every 6 months.
So that one check was just $87.
Yes, ma'am.
Okay, that's all. I'll pass the witness.
But that's on top of them paying your rent in addition to that. Is that correct?
No, no, it's not. It's just we pay what? How much is a negative what?
And let me ask Mr. Brianna, is that a section?
I'm sorry.
Is that with the housing authority somewhere?
Yes, ma'am. Yes, sir.
Okay, all right, I'm familiar. And the reimbursement check they give you is for utilities or?
It's for whatever that we need it for.
Go ahead, counsel.
I have nothing further, Your Honor.
I have nothing, Your Honor.
All right. Any other witnesses?
I just have for attorney's fees, Your Honor.
Would you raise your right hand? You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Go ahead.
I'm Grace Brewer. I've been practicing in Wilson County and surrounding areas for over 16 years. I customarily charge about $300 per hour, which I think is customary in this area, for the filing of the enforcement or to revoke the enforcement. And we've come to court. This is our second time in court, and I've approximated about 5 hours total for everything. So we're asking for about $1,500 in attorney's fees. And that's all, Your Honor. That I feel is reasonable and necessary in this case.
All right. Cross-examination?
I don't have any, Your Honor.
Okay. Argument on the merits?
Your Honor, my client did wait a while. She actually had come to me a couple times throughout this last 8 months saying she needed the help. I told her to just give him a chance, see if he can, try to see if he's going to make payments or not, especially due to COVID happening when she first came in, saying he didn't follow through with the order. She did that. She tried to get help, especially after she stopped working. She's in dire need of help. At the last hearing enforcement, you heard all the testimony regarding Mr. Bryan's supposed disabilities and medical conditions. Again, still have not had any medical documentation from anything showing all this is happening. Last time we were waiting for disability hearings that had already been denied, and we're waiting for appeals. And Ms. Bryan is just really suffering in regards to needing help, especially with a teenage son. And her, just finishing up school. I believe Mr. Bryan could have found something, even if it was $25 a month he could have paid, knowing that we had gone through a year-long process of this, and you had finally given him a chance and put him on probation. And the first month after we left court, he failed to comply. So unless his feet are put under the fire, he does not do anything to help her. And my client just wants to see that there's consequences for what happens. And she's asking for you to revoke his probation and send him to confinement.
Ms. Tapia?
Your Honor, we ask that Mr. Bryant be allowed to pay a lump sum, and then, the $1,500, and let the rest be taken care of with the modification. If he is incarcerated in the Karnes County Jail, he's going to miss his hearing on the December 14th, unless if the court should decide to do that, he goes into custody sometime after that. As Mr. Bryant testified, employment would disqualify him from proceeding with his disability claim. And because of what he's suffering from, he cannot work. Further, he is a high risk for COVID, and with the increase in cases that are going on right now, I would propose that to put him in the county jail would potentially expose him to COVID more so than just being shelter in place right now. So we're asking that the court again allow him to make a lump sum, and then we would confirm the arrearages and put that in with the new child support order that is coming down the pipeline.
Okay, and what sort of lump sum are you considering?
As he had testified to, that he could possibly come up with the $1,500 within 10 days.
Anything else on either side?
No, Your Honor.
I will hold Mr. Bryant in contempt. I will sentence him to 180 days in jail. I'm going to order him to report by 5 p.m. this afternoon. But if he does that and surrenders to the sheriff's office in Karnes County by 5 p.m. this afternoon, I will order that he be furloughed at 8 a.m. on December the 8th. That would give him an opportunity to be able to confer with his attorney and attend whatever hearing he has on Social Security, whether it's by Zoom or in person. And I will then set the case for further proceedings on December the 15th at 9 a.m. with the requirement that Mr. Brown's furlough ends at that time, and that has to be at the Karnes County Courthouse in the district courtroom by 9 a.m. on December the 15th. And I have not researched it recently, but I'll represent to everyone, and let Ms. Tapia let you speak to your client about that if you wish, that there is case law that says that failing to return from a furlough will support a charge of escape. Okay, and I will award $1,500 in attorney's fees to the petitioner. And I'm not going to order a number for the respondent to pay, but obviously the more he has paid, by the time we're back in court on the 15th to review whether we're going to continue his 180-day sentence or do something else, the better. All right, so I was given a proposed order from Ms. Barrera, other than the information about furlough at 8 a.m. on the 8th.
Did I give you an order, Your Honor?
I'm sorry?
I'm sorry, I didn't give you an order. Did I send you an order on accident?
I thought you had, but.
It might have been the last order for you to see.
Oh, that was probably it. Okay. All right, so I need to meet with some folks from Pleasanton on a search warrant, so I'm gonna mute this and ask the attorneys to confer. I'll be back. You don't have to go to a breakout room. I'll just shut my microphone off.
Do you want me to work on an order, a guideline order?
Yes, so see if y'all can work out the language right now. Okay. We'll be back in a moment. I'll leave the video on, but I'm just gonna mute my microphone and my speakers.
Okay.
Okay.
Thank you, Judge.
Thank you, Your Honor.
Okay. So my understanding is he sentences him 180 days, and he goes in today at 5 p.m. noon, and
Right.
he gets furloughed at 8 a.m. on December 8th. And then he goes to his furlough's going to end. So he'll have time to go to his thing. His
Right.
furlough ends on December 15th at 9 a.m. And at that time, the judge will determine if he brings in a lump sum, if he needs to continue his 180-day sentence.
Correct.
And $1,500 in attorney's fees, right?
Correct.
Okay, I'll see if I have something that I can use as a sample and then tweak it a little bit.
Okay.
So I guess I'm gonna work on that. I don't know if he's coming back. You want me to work on that, and then I'll just leave my screen open in case he comes back.
Okay, that's fine.
I'm back. Are y'all still confirming or?
Well, we agreed on what the order, I'm sorry.
Forgot I turned the speakers off. Go ahead.
We agreed on what you said for the order, and I'm just working on a draft of it to send Jennifer.
That's correct, Your Honor.
Okay.
Do you want us to leave and come back, or just email it to you, or what did you?
However you want to do it.
It might take me about 10 or 15 minutes, so.
Okay. I tell you what, I got lots of things to work on. I'm gonna sit here and work. I will just mute my computer,
Okay.
monitor. But if you need to have any hearing to clarify it, that's fine. Otherwise, just say something and I will turn this back on. You can just send it to me in chat and I'll sign it.
Okay, thank you, Judge.
Well, Vishay, I think that's all we need you for.
All right, Judge. Have a happy Thanksgiving.
You too.
Judge,
Yes.
I just had a quick question. It's given me two options on the attorney's fees, either to be paid by a certain date or to have a judgment to be included into the child support arrears. Which one do you want me to do?
Included in the child support arrears.
Okay, let me fix that.
Would you prefer something else, or?
I mean, a certain date, but then I would just have to file an enforcement for it. So I think the judgment's probably the best route.
Ms. Tapia?
No, I would agree, Your Honor. I would request that it be part of the arrears.
Okay.
Okay,
All right.
I'll fix that.
And I am giving him credit for the informal payments. If that was,
I think I was just about to ask him as well.
Okay, I wasn't doing a confirmation of arrears on that, so I can have her fill out an affidavit of direct payment to give him credit for that.
Thank you.
Your Honor, I just wanted to let you know, I put it in the chat.
Give me just a moment.
Yeah, sure.
Okay, I changed the courthouse to Wilson County and I put a further order in there, making it clear that the Karnes County SO is supposed to cut Mr. Brand loose without any further order from me at 8 a.m. on the 8th. And I've just sent that back to everyone. Is the clerk's office online or are y'all at lunch? Okay, it looks like the clerk may be at lunch. I'll leave this running. I've got to run some errands. When I come back, I will contact them.
Okay.
All right, and Mr. Brianda will probably need a copy of this order, a written copy of this order to take to the jail with him, just in case they haven't received one.
Okay, and I think there's something I need to file with the district clerk that they attach the order to give to the jail too, so.
Sorry, cut off.
Judge, we're here.
Oh, okay, all right. Thank you. Good afternoon. Okay, I just posted a signed order in the Briand case.
Okay, Judge, I'm gonna print it. Let's see.
Okay, and you can always just save it as a PDF and then file it directly. That would save you that step of printing and scanning.
We don't have Odyssey here on this laptop though. That's the only thing.
Okay, all right. All right, anything else?
That's all, Your Honor.
No, that's all, Your Honor. I'll instruct my client to go by the clerk's office to get a file stamp copy of that order to take with him to the jail.
All right. And Ms. Rodriguez, have you been able to get a, or download the order? Hello? All right, everyone's released. I'll just leave this running in case the clerk is.
Okay, thank you, Judge.
Thank you, Your Honor.
Judge Wilson, can I go over the docket with you by chance?
Not right now. I'll send it to you. I've got to go run some errands, and but I'll send it to you in a little bit, and then we'll go over it.
Okay, and then quick thing, you have
Judge,
a special setting for tomorrow,
sorry.
remember that one?
At what time?
At 9 a.m. with Teresa Nettles, and I'll double check with her just to make sure she needs it or not.
Okay, I appreciate that, and yes, I'm gonna have to do that from the house, but I'll
Okay, I'll check with her and then I'll let you know.
All right, thank you.
Thank you.
Judge Wilson, did you have a question for us? I'm sorry.
I just wanted to make sure that you had gotten that document I posted.
Yes, Judge, I just printed it.
Okay, excellent. Then I'm gonna go ahead and leave the meeting. You'll have a good Thanksgiving.
You too. Happy Thanksgiving.
Bye-bye.